The revenge of the Obama-era judicial nominees. Two cases, actually three if we can get to the third, that show you just how certain judges can have an outsized influence over the policy of this country, the President of the United States, and your lives. First, a federal district court judge on Thursday denied a Trump administration request to dismiss a lawsuit challenging its decision to add a citizenship question to the 2020 census. A policy, by the way, that is completely constitutional, completely sound. Judge Jesse Furman from the U.S. District Court for the Southern District of New York, a Barack Obama appointee, said that the challengers had successfully proven that there is, quote, a heightened risk in the current political climate of a lower response rate due to the president's, quote, anti-immigrant rhetoric. I kid you not. That's not a pundit. That's a judge. That's not all. A federal judge in Portland, Oregon, has ruled that allowing a transgender high school student in an Oregon school district to use the boys' locker room and restrooms does not violate the privacy rights of other students who may object to sharing that space. U.S. District Judge Marco Hernandez, you guessed it, also an Obama appointee, threw out the lawsuit filed by Parents for Privacy. They wanted this group called Parents for Privacy in Dallas, and saying the ruling, if the parents are upset, well, they can, quote, just remove their children from Dallas High School if they disapprove of the transgender student access to these facilities. Oh, thanks. Well, to discuss this trend of the politicized judiciary totally run amok, let's bring in two top attorneys. Harmeet Dillon is a civil rights attorney and an RNC committeewoman from California, and Scott Bolden, chair of the National Bar Association Political Action Committee. I'm lonely in here without either of you, but I'm going to have to make do. Scott, you're usually here, dude. You're not here. Come on. All right, let's start with you, Harmeet, on this citizenship question on the census. Up until 1950, we did have that question on the census, and the census changes, and we didn't ask that question. But tell us about the posture of this case and this particular judge, Jesse Furman.
Well, Laura, what's happening here is that these judges are, taking these cases and really imposing their own judicial philosophy and new standards that are not written into the law into these cases. And, you saw the exact same reasoning that Judge Furman used here, which is that Wilbur Ross, who's sort of nominally in charge of the census in his department, had made some remarks about the reasoning behind wanting to count citizens that raised an issue of animus. Now, the United States Supreme Court recently ruled that this animus theory, which was used in the Trump travel ban cases, is bogus and not one of the elements and shouldn't be applied. And Clarence Thomas has spoken out on this issue as well of nationwide injunction. So basically, this is a confusion, and we have an unelected judge trying to supersede and impose his values over what the president gets to do, asking a very reasonable question in the executive branch and counting. That's the purpose of the census, is to count the people in the country. Why are we not counting some of them?
Well,
they're counting.
They're counting all people. Hold on, Scott.
Count the immigrants then.
No, they're counting all people.
Count the immigrants.
Scott, hold on. They're counting all people, but there's also a question about whether you're a citizen or not. Now, what's the problem with answering the question? Well, I don't understand that. What is the possible constitutional argument here?
Well, because it's racially offensive, first of all.
Well, how is it to do with race? It's whether you're a citizen.
Well, because it's directed at brown people and black people who are coming across that southern border. Of course it is.
How is it directed at brown people? It's directed at all people in the country. You ask a question. I get asked the question. Raymond gets asked the question. You get asked the question.
Racist tweets about immigrants. When you couple that with Donald Trump's tweets about illegal immigrants, regardless of the Supreme Court, the judge has taken that into consideration. And by the way, can I just say this? That case wasn't just rested on discrimination issues. The APA was violated. The court found that despite the advisory committees as well as staff ruling against it or recommending against it, Wilbur took on it upon his own to put it in place. The case isn't over, by the way. They just got past a motion to dismiss, so it's not the final decision. It's not political.
It isn't the final decision.
The law.
Right. But to say that it's racial,
you politicize every legal decision you don't agree with.
No, but Scott, now you're saying a question asked of all people is racist. All Americans would have to answer that question. That's unbelievable.
It has a disparate impact.
You're a smart guy.
It may not be racist, but it has a racially disparate impact because it's directed to people.
It's absurd.
To Mexican immigrants and brown and black people.
All right, we got to move on. We got another case. This is interesting out of Portland, Oregon. It's involving transgender bathrooms. We've heard the transgender bathroom case and issue for a long time, but this is interesting because it's a parents group that's gotten together and said, okay, we understand that transgender kids have rights, but we represent families whose sons and daughters do not want to share a bathroom for whatever reason with a transgendered person who's born of the opposite sex. And this judge said, you don't get any privacy rights here, and if you have a problem, leave the district. Harmeet, is that the kind of thing that would survive scrutiny? I know that's the Ninth Circuit, so anything goes in the Ninth Circuit, but that seems like that seemed kind of like a harsh ruling against that parents group, but maybe I'm misreading it.
No, I agree with you, Laura. I think it's harsh and it's wrong. Now, obviously, transgender students who I think, may need, a number of supports and medical support they have rights, obviously, but the vast majority of the students are not transgender, and they have rights, too, including their privacy rights. And, people who are transgender in their youth, they may switch back and forth. The specter has been raised, which I think is a real one, of people abusing this transgender labeling and electing it in order to, peep and get into the girls' bathrooms. It's not really, appropriate to only look at one side or the other. And I can tell you, in girls' locker rooms, we've been there, Laura. I mean, everything is showing, and it's not really something that you want as a teenager to have a guy looking at your body, I'm sorry to say.
I didn't like other people. Any girls looking at my body, I was like, I don't like anyone. I was like covered with a towel. I was one of those shy people.
It's true. But it's a slap in the face for the judge to say that the taxpayer, the parents are taxpayers. The parents are taxpayers, and they have a right to have their kids educated fairly and without this type of invasion of privacy.
Yeah, we're almost out of time. The parents have any rights here, or just the transgender kids?
Not compared to the protected class that the transgendered student rests in. And look at it this way. The judge is just following the law. There's no politics here. Every federal judge that's looked at this case and looked at other similar cases around the country, you check the record. They have sided with the transgender student because they cannot be discriminated against simply because they identify with being a woman or identify with being a guy. It's not anatomy that counts, and they're in a protected class. And so this decision is based on the law, not politics. You may not like it, but you got to live with it.
Harmeet, last word.
I mean, anatomy obviously does count, and it is relevant, and the other students have privacy rights too. There needs to be a balance, not just one-sided.
There has to be some balance.
The judge says that was conjecture.
Yeah.
Pure conjecture that you're going to be naked and you're going to have peeping
Maybe the judge doesn't. Maybe the judge is not living in reality.
Scott,
give me a break.
But Scott, I know these fraternity brothers where I went to college.
Somebody else not living in reality on this panel.
When I went to college, these fraternity brothers are like pranksters. You could see a situation. Let's say, okay, I identify as this today, and then tomorrow this. These people playing jokes all the time too. So that's a serious matter.
Issue.
But then there are pranksters out there who will take advantage of it.
I don't think you and your guests take it seriously. The plight of these young people who identify with a different gender. It's serious. They're in a protected class.
Scott, I have friends who are transgender. I
got to tell you.
Read the research of Dr. Paul McHugh if you want to know what serious is. All right, we're out of time. By the way, I want to say to Harmeet.
I read the opinions of both of these cases, and the opinions are accurate.
Read Dr. Paul
McHugh.
He's a medical doctor, studied it for decades. Harmeet, I want to congratulate you on the Ninth Circuit ruling that your case, your civil rights case against those people who beat up those Trump supporters, you've represented them. And you've done it pretty much pro bono the whole way. The Ninth Circuit said your case can go forward. We're going to be watching that very closely. You had a great argument. Congratulations on that. And thanks to both of you for being here tonight.